I'll have to go in a little while. Let the debate start.
Mr. Deputy Chairman, sir.
Narayan Swami.
I'm extremely grateful to you, sir, to permit me to speak on these two bills. The first seeking to create a national investigative agency, and the second bill amending further certain provisions of the Unlawful Activities Act. Sir, I must confess that I speak with a mixed feeling. The mixed feeling is that my party and others who support us could derive at some stage some sense of satisfaction that at least in some areas, if not all, what we have been very strenuously saying for the last 4 years and 7 months, that a strong legal mechanism is also required to investigate and punish terrorism. The reason and the rationale that we have set out for this, at least a large part of what we have said is now being finally accepted by the government. We might even get some satisfaction from the fact that most of the arguments which were used to repeal the erstwhile anti-terror law, POTA, are now proving to be spurious. We can also get satisfaction as a country from the fact that there is a near unanimity, both in the country outside as well as in this House, as also in the Lok Sabha, that these two legislations are required. But we are at the same time concerned about the fact that the measures which government have taken are still not strong enough and still fall short in a large measure as a legal mechanism for fighting terror. Sir, we are also concerned, and I am sure every Indian is concerned about the fact that what has brought this consensus is not really the sound and strong logic that we have been giving to this government for more than 4.5 years now. Where reasoning failed, where our rationale failed, I think the 10 evil men who entered Mumbai on 26/11 and shook the conscience of this whole country succeeded in persuading the Indian society that India can no longer afford to be a soft state and must finally start adopting hard measures if it is really serious about combating and fighting terrorism. Sir, I remember that there were different reasonings given why India did not need a strong anti-terror law. When POTA was repealed, I was looking back at the debates, and even when it was first introduced, I was reading the debates. The country was repeatedly told by the opponents of a strong anti-terror law that a strong anti-terror law is not per se against terrorism, it is against minorities. The country was then told that normal laws in India are enough to tackle terror, and when you have so many normal laws, why do you need a special law to tackle terror? The third reasoning made out was that a special anti-terror law per se would be opposed to the constitutional guarantees and human rights. And as a Republican constitution, we can't afford to have a strong anti-terror law. We were then told that there is a huge scope for misuse and abuse of this law. And since there is a scope for misuse and abuse of this law, it's much better to go by the normal laws and not have this law. And lastly, sir, an argument was repeatedly raised, and I have seen a large number of my friends raising this argument only till the other day, in and out of this house. But anti-terror laws don't prevent terrorism. Despite Pota, an attack could take place on Akshardham or it could take place on Parliament. And since despite an anti-terror law, attacks can still take place by terrorists, what's the point in having a special anti-terror law? Sir, I repeat that the 10 evil men who entered Mumbai on 26th November have shaken all these fundamental assumptions on basis of which a strong anti-terror law was being opposed. And today, with the kind of measures which have been announced, plus some additional measures which have still not been taken by this government in this law, it appears that the government now also believes that all these assumptions which were being given to oppose a strong anti-terror law were really spurious assumptions, they were fallacious assumptions. Sir, it is obvious to anybody who understands how a fight against terror and insurgency can take place that a battle against terrorism is not fought in the courts of law. Terrorism is not something that can only be fought through legislation. An anti-terror law is never a substitute for a strong preventive intelligence. An anti-terror law is never a substitute for a strong security action and a quick reaction commando action against terrorism itself. To fight terror, you need a large number of steps. If it's cross-border terrorism, if it's internationally engineered terrorism, you perhaps need a global consensus. You may even take foreign policy initiatives and work for a global consensus for sanctions against countries and states which encourage terrorism. You require a very strong intelligence network to fight terrorism. Not only within your own country, you require a strong intelligence network which infiltrates into the enemy camp and pre-warns you of what is likely to happen. And then you require that intelligence to be shared with those who require that adequate intelligence information and the follow-up action to be taken, which at times we find we are lacking in not taking that. What we do as a security response, our lasers, is not relevant. Our quick security responses, our immediate security responses really determined, because if we take action after hours, the terrorists have already won. They've created a global impact, they've created a national impact, and therefore these are essentials which are required to fight terrorism. An anti-terror law or a machinery to investigate terrorism, whether it's a central agency or a state agency, comes into the picture not as an agency or a law which can prevent acts of terrorism. It's not an agency which can really start distributing intelligence all over the country. It's not an agency which will per se have a security force at its disposal to prevent terrorism. That has to be done by the various agencies which are earmarked for this purpose. The law and the agency comes into the picture either just about when an act is being planned or when an act has just been committed. And therefore, for the purposes of collection of evidence, investigation of that crime, punishment of the criminal, you need a law and you need an agency which is effective. You need a law which can adequately collect that evidence, which can bring out that evidence and put it at the disposal of the prosecuting agencies, and then the conviction of those involved in acts of terrorism becomes simpler and easier, so that your conviction rate goes up And when your conviction rate in terrorist offenses goes up, it's a deterrent for those who commit act of terrorism not to indulge in their acts. The preventive impact of this law is it reflects the determination of the government and the Indian state in fighting terrorism. And the Indian state then is adequately equipped in terms of law to investigate the crime and expeditiously punish those who are responsible for that crime. As I said, the battle against terror is never fought exclusively in courts or through a legislation. You have first to equip the minds of the government and the agencies of the government. It's in the hearts and minds of the people of India that they must get ready that we are a state which is on the terrorist radar, and therefore we must equip ourselves to fight terror. It is through these acts that the determination of the Indian state in fighting terror is expressed. Unfortunately, 95% of the tenure of this government is over. And that 95% of the tenure of the government it spent in convincing each one of us why a strong anti-terror law was not required. And different arguments, as I have already explained, were taken out to establish that these are not essentials which are required. And an effort was being made. And I am afraid, even though the Home Minister's bill indicates to the contrary, what some of his colleagues have been saying still indicates, and that's what we are concerned about, that the battle against terrorism is to be diluted because you think the battle may prove to be politically costly, and therefore the vote bank signal which has to be given is to the contrary. Well, I don't think it's a matter where any one of us can really be amused, because the argument really is that when you have both houses of parliament debating on this bill, at the same time you have a colleague of the Home Minister making a statement yesterday which is flashed on all front page newspapers of our western neighbor. The blogs coming out of Pakistan are full of it. Look, we always said so. Now that's a signal which I am referring to. And that's the signal which your government spent 95% of its recent tenure in giving, rather than in taking substantive steps in fighting terrorism. Sir, even though we found some aspects of this law to be inadequate, my party had announced very categorically that we would support these bills. Even though we said that these are half a step, we would support a half a step against terror, but continue to campaign for the other half, the seriousness of which the government may not have realized. I am conscious of the fact from what the newspapers report, that the Home Minister can't really be blamed for it, because the newspapers, at least if they are to be believed, did indicate that he tries to bet his best to get some more provisions. But some of his colleagues were perhaps concerned with forthcoming elections rather than the security considerations which were inbuilt in those suggestions.
Unfortunately, our newspapers sometimes report wrongly. The bill that was brought by my ministry, by me, to the cabinet is exactly the same version that was introduced in the Lok Sabha. Nothing was added, nothing was deleted. The cabinet unanimously approved the draft that I brought.
See, unfortunately, we have a cabinet which has too many spokesmen, and therefore each ally of this government, each ally of the government seems to be taking credit for diluting this bill. Sir, I'm glad that the Home Minister has clarified this, because then I would like to withdraw the little compliment that I gave him, where I thought that at least he had realized the seriousness and the gravity of the situation and tried to bring in something which he honestly admits that he did not bring in. So in order, therefore, my primary task would be to convince him so that he can convince his colleagues as to what further is required to be done as far as these laws are concerned. So in order to just simplify the issue, let us for a moment, before I go into the abstract of what is required and what is already there, just discuss and place before this House that what is it essential which is required in the investigation of a terrorist offense. A terrorist offense per se is not like an ordinary crime where eyewitnesses would be easily available. A terrorist offense per se will have conspiracies at times which are hatched in foreign soil. You'll have some people, the Fidain, the jihadi terrorists, the suicide squads, who are not scared of dying, who are not scared of the prohibitions contained in the law, who are not even scared of the consequences of the law. And therefore you will always have a larger conspiracy behind the apparent terrorist acts. We can analyze any one of the terrorist cases which have recently taken place. Let me just point out a glaring terrorist case recently took place in Mumbai on 26th of November. On the surface, 10 terrorists came by the sea route, attacked various vital places in Mumbai. 9 out of the 10 are killed, 1 is arrested. What happened in Mumbai is extremely easy for Indian police to prove. You have eyewitnesses. You'll have various other evidences. You'll have reports of experts. And it won't be a difficult task for an Indian investigative agency to prove it against those 10. But 9 out of the 10 are unfortunately not there. It's a rare case that a terrorist has been caught alive. Ordinarily, they are not caught alive. But the real conspiracy is not merely those 10. The real conspiracy in this case is, and that's where your law is lacking, who were the people who trained these 10 across the border? There were obviously some training camps where for a year, year and a half, these people were given extensive training. Funds were made available to them. Their families were assured that monies would be given to their families in case anything happened to them. Weapons and equipment was supplied to them. RDX was supplied to them. It is possible that such an operation could not have been carried out without the support of the official agencies. Who were these people who organized the entire conspiracy across the border? Pakistan is living in denial. Their High Commissioner made a statement yesterday, their Foreign Minister made a statement yesterday that Masood Azhar is not in Pakistan, conflicting what had been said earlier. Pakistan as a state which is living in denial will continue to deny. Pakistan doesn't seem to be in a mood to render cooperation. And therefore the responsibility is ours, the onus is on us to prove the Pakistan link and the Karachi limb of this conspiracy. Now the terrorist who has been caught alive is speaking. His statements are being published. And his statements are being shared with the entire world. But under this law, with adequate safeguards, and I underline and re-emphasize the word adequate safeguards, if Kasab's statements to the investigating agencies are not evidence, then we may well be reading just a news in a newspaper which is not evidence in a court of law. And Pakistan would then turn around and say, what Kasab is saying is not evidence under your own law in your own country. How do you on the international forum make it as an evidence against me? Let's move a little backwards. One of the most glaring cases in India, the late Shri Rajiv Gandhi was assassinated. When Shri Rajiv Gandhi was assassinated, TADA was in force. Though eventually the Supreme Court did not convict them under TADA because of some interpretation of the definition of TADA, but the Supreme Court still applied the rules of evidence of TADA. The human bomb, the lady with a human bomb killed Rajiv Gandhi on spot. The actual killer died on the spot. 50,000 people witnessed that killing. And yet when the matter came to court, our SIT went to the first conspirator, those who supplied the vehicles, those who supplied the arms, those who supplied the shelter, those who harbored them, those who planned the conspiracy. Our SIT got all of them. The SIT did a remarkable job in reconstructing the whole crime. And finally the SIT found, just as we don't have any eyewitnesses of what happened in Karachi or the terrorist training camps, the SIT did not have any eyewitnesses of what the conspirators were doing behind closed doors. Conspiracies are hatched in darkness. They are behind closed doors. They don't leave eyewitnesses behind. So it's only when the first conspirator sang, the second conspirator spoke, that their evidence under TADA became admissible evidence, and the conviction of the other accused in the Rajiv Gandhi assassination case took place only because of the admissibility of those confessions. Take those confessions out and this country would have been a laughing stock, where a former prime minister is assassinated in front of 50,000 people and you wouldn't have had a conviction in the case. The actual assassins had died on spot. Take the parliament attack case. The 5 actual persons who attacked Indian parliament died within this premises itself. It's the conspirators who were arrested. And the most material evidence against the conspirators is a lot of what some of them, the first man and the second man who were arrested, those who spoke. Now it's always been said, and this is not only in this case, and I'll come to it a little later, what is it which is required in a strong anti-terror law? And I always tell my friends in the government, when India